My name is Marty Schenkman, and I'm joined by three colleagues, actually from all over the country. Latanya, Tom, and Sonia. Latanya is in California, right?
Yes,
And Tom is in New Jersey, and Sonia is in Florida.
that's right.
So we got the country covered. This program was initiated and thought of because of National Make a Will Month. And I will say it's really critical that everyone that's an adult have a will, but also much more. And we're going to talk about that. And what we want to do is provide a little deeper understanding of what a will is so consumers can act on it, but also to try to educate consumers about what else really goes into the process if you really want to help yourself, your loved ones, and do things that really work for you. Because even though it's a brilliant concept to try to build awareness, and we're going to go through some of the statistics, and they're awful because a large portion of people don't have anything done. And that's good. But we want to, again, expand the discussion. So we're going to get started. We have a lot of resources that we've created that will be on each of the websites listed below on the last slide. So Latanya's website, Tom's website, my website, and shankmaneducation.com as well. There's going to be a very significant paper that gives you lots of background. And I hope and I believe, we all believe it's written in English, but again, written at a level where you will learn real information, not sales pitches. And we have a guidebook of will provisions so that if you're trying to understand what a provision is in a will you have, whether it makes sense, whether it doesn't make sense, or if there's a provision missing that perhaps you should have, that may give you some ideas so you can follow up however you choose. We're also going to do something very different, even though we're all lawyers. We're not going to only tell you have to go to an estate planning specialist because the reality is many people cannot afford an estate planning specialist. So we're going to give you practical ideas of what you can do. And that may be a point in the webinar where I pipe up because I have some very, I think, practical ideas of how consumers can use inexpensive resources to get some of the stuff done that we're talking about. If you're a wealthier consumer, we're going to try to really educate you about why you need more than just a form document. So let's get started and we can go. I see us in order of Latanya, Tom, and Sonia, so we could just go in order. Maybe comment, Latanya, about how many people don't have any documents. And if you want to address how it goes up with age, that's important too, because it really suggests that younger people have nothing.
Yeah, the numbers definitely show that people, I think over 60, 60s and 70s are more likely to have a will, whereas younger people are not. And it makes sense because younger people tend not to really think about their mortality. And as you get older, things of that nature start to become a little more prescient for you. And so it makes sense that as you get older, you may be looking to get your affairs settled. I see that often. And I've just really found that if we don't, as the professionals, get out there and start talking about the importance of this and why they need them at a young age and not to wait until you're older, I really see it as being upon us to get out there and start spreading that message. If we just wait for people to find us, I think these numbers will stay the same and we won't really see any growth.
And we need to see growth, not just because of the business attorneys need, but because it's really tragic that so many young families, especially families, don't have any documents. If you're young and single and don't have any kids, yes, if something happens, it's tragic. And yes, if your money has to pass under state law, it's probably not what you want. And we're going to talk about intestacy. But if you have young children and God forbid something happens and you haven't named a guardian, you haven't set up a trust for your children, that's really tragic for them. That's especially bad. So I think part of what's motivating all four of us is that we want to make an impact to help all the consumers, especially those that are younger or on the lower ends of the economic ladder that aren't doing any of this. Tom, maybe comment on the 42% figure.
Sure. So one of the things to consider here, and I just want to acknowledge before I jump into that, that this is a difficult topic. It's both the fear of unknown, it's also facing your own mortality. So these percentages reflect the fact that this is a tough human element to do planning. But if you act like you're an ostrich and you stick your head in the sand, it's not going to help if there's something that happens. And the 42% figure, people don't know what they would be able to do if a family member died today. if you don't have that knowledge, there are things that that could affect and negatively hurt both your planning, your family members, and the future and what you've tried to build if you don't take steps by a certain point. And if you don't know what you don't know, you're not going to have the ability to take those steps and protect it. Our world is becoming a more dangerous world as time goes on. There are bad actors out there. There's financial abuse. You hear all the time about people using AI or the internet to steal money, not just from the old, but from people. There's phishing emails. We all get them these days. There is a lot of little nuances that if you build these guardrails and these safety points into not just a will, but your planning, you're reducing the risk of that happening. And we all work very hard to build what we have in our lives. It doesn't matter how much you have, what you have, you worked hard to achieve it. You don't want that to be lost because you didn't spend the time to protect it here. We spend a lot of time building it. Let's spend a little time protecting it as well.
Sonia, you get the best part of the slide. Tell everybody why a will alone is not enough.
Okay, so to add to what Tom was saying, aside from not losing everything, when you have a will, you're basically prescribing instructions to go to court. And when you go to court, we all know what that means. That means lawyers are going to be involved. That means very high likelihood for conflict. What kind of conflict? Litigation, financial, creditors, sibling, family disputes. I can go on and on with horror stories about family disputes. We're talking Jerry Springer style shows live in action in front of a judge. And some of these situations are more complicated than others. Some of them are very surprising because the estate itself had very little in it, but it is the perfect recipe for high emotions. I think even higher than divorce court because there's mourning involved here too. So you have the pain of having lost that loved one, but now all of your insecurities from childhood, your sibling rivalry, your jealousy, preferential treatment, et cetera, all come up to the surface. And that equals expensive, emotionally and financially. So all of these things can be avoided. How? With something much more than a will. A complex, a real estate plan. And I'm sure we'll talk about that, Marty. I don't want to take over. But
will.
those are the types
will.
of things that a will is not enough for, to protect against, basically.
So the next slide is part of the motivation for doing this program. If you look at the statistics, there's a high correlation, no shock, of people with more money, more wealth, more income having estate plans and people with less money, less income, less wealth, not having anything done. But Tanya, we can't belabor it too much, but this is really important. Talk to this for a minute.
It really is. One of the
And
things
we want to motivate everybody that's not doing this to realize they should do it and they need to do it.
Yeah, one of the things you see often in looking at the data and just what I see in my own practice, a lot of people believe that they do not have enough wealth to plan. So they really just correlate estate planning with wealth. And so it really takes someone to explain that it's much more than just that. And my process is set up to reveal this to people. And so I address head on the idea that, because along with I'm not wealthy enough, is I'm not old enough, all the reasons people come up with, it's not, people don't feel comfortable talking about it. And so I address those myths head on. And then I actually sit with families and we talk about what assets they do have. And so instead of just telling them, I like to show them. And so I take the information I get from their intake form, which I require they have as much done as possible before we meet, so that when we meet, I can show them in the numbers what this looks like. A lot of people aren't aware of what they have when we look at what they have in the bank. In California, the home prices are crazy right now. And so I have so many families, especially my elderly clients, who have homes that are paid off. They have no mortgages in homes that are almost $1 million, and they think they don't have enough to plan, which is crazy. And so when you show them not only the wealth they have in their homes, some have multiple homes, but also just in their accounts. And we look at retirement and insurance and everything together, then the light bulb goes off and people see, oh, that's more than I thought. And once I see that light bulb go off, I know they're ready to move on and listen to, now what can we do to protect it? What are some options that you have? So I think sometimes you have to show people real numbers.
So you just made me realize something that I missed. Why don't you explain just very succinctly what this organizer questionnaire is and how it can be used, and what either we'll use 1 or 3 or 4, but we're going to add to the materials that we put on our websites, which we're going to make available for free to everybody. We're going to put an organizer, because this is something, if you cannot afford an attorney, you can download one of the organizers and go through the process LaTanya is going to describe. And if you have your own attorney, you could use their forms. But if you just want to get the process started, like LaTanya said, many lawyers bill for their time. If you get things organized before you talk to them, you're going to save some money. Not a bad thing to do, even if you're wealthy. Explain what the organizer is and why people should do it.
Sure. It just gives me basic information about who I'm talking to. And so when I have consultations, when I'm doing one-on-ones with clients, I really want that time to be targeted. And so the more I know about them, the more targeted I can make that time enough where they can complete it in 15 to 20 minutes, because I don't want it to be so challenging that people don't finish it.
I'm not sure if
Come
LaTanya's
to the meeting because oh no. Can you hear me now, Marty?
Yeah, your internet was fading out.
Okay, I'm sorry about that. What was the last thing you guys heard?
Not to be overwhelming, and people
Okay.
should finish it.
Okay, so yeah, I try to make my form where I can get enough information to have the conversation, but not to the point where it's overwhelming and they don't finish and don't
Yeah,
come.
ours is probably overwhelming, but for
I've
anyone
been there
listening,
too.
we're going to give you some materials.
Yeah.
If you're doing this online and you don't prepare an organizer, you're not organized to go and use an online will or trust service. You're not.
That's
And
true, because you need that information.
correct. And the big beef I have against the online services, and I'm trying to be respectful and acknowledge practically, many people can't afford to hire a lawyer. They have to go online. What the services that are online don't do, they don't give you an organizer. They don't require you to watch a video to learn about the document you're about to prepare. You need background to use it. So we're not going to say don't do it more wisely. So let me add one point on this slide, and it's probably worthy of a webinar on its own, but we're not going to do it. We're going to move on, and I'll get to Tom. I want to propose something. For the people with lower income and lower wealth that have no documents, it's not only about getting a document, because if you have children and God forbid something happens, you need documents. You need to name a guardian. You need a trust for your children. Also, very important, people do exactly what LaTanya said. Oh, I don't have enough money to do documents. But you know what? If somebody's worth $20 million and fights, as Sonia described earlier, and legal fees and fights and whatever else, with $18 million, I think the heirs will do fine. They may bellyache, but they'll do fine. When someone's got $50,000 or $100,000 and it's going to 2 children, if they lost 20,000 of that 50 or 100,000, that could be the difference of a kid going to college or not going to college. So it's more important for people on the lower rungs of the economic ladder to do the planning. And here's a thought. It may be novel. I don't know that I've heard it anywhere else. I think if you go through the process, filling out an organizer, like LaTanya said, thinking through the decisions to make a will or trust, etc., I believe for people on the lower economic rungs, that very process of going through this process of getting your documents and your planning and thinking like this, I think is part of the catalyst to building wealth, because it focuses you on how to be responsible for your wealth. And I think if we could do more to encourage people in the lower economic rungs to do the kind of planning that's appropriate for them, not appropriate for somebody with more money, but appropriate for them, it will help them enhance the wealth that they ultimately leave. So let's go on. This is a roadmap, Tom. Why don't you just give us a quick overview so people know where we're going?
So I'll give a quick overview, but I just want to give one of my examples for people to think of. And this kind of touches on the online preparation services. So think of planning as like a house. You need to build the house around yourself to protect yourself. The online tools may give you the construction materials you need to create a house, but they don't give you the instructions on how to actually build that house. Doing the organizer, like Latanya mentioned, considering what's important to you. What steps do you take in your daily life to maintain your finances, to take care of your kids, to do what you need to do? Do you give to charities? Those kinds of aspects, and we'll talk a little bit more about that as time goes on. If you put it down to paper, it helps you understand and also provides a resource material for other people that may step in if you can't take care of it yourself in order to transition in a more understanding and easier manner. So we've got a couple of points here. I'm not going to touch on this for very long because I want to actually make sure we get to all of these points. But plan first, document second. You need to understand what you're going to do and what steps you're going to take before you actually put pen to paper. It's important to know first, like you don't want to try and put every shaped item into a round hole. You can't put a square into a round hole. You can't put a hexagon into a round hole. So make sure that you've got it lined up properly first. What a will does and does not do. I'm going to just move past that one, but there are many points that can be tripped up in your planning, especially with modern financial aspects of transfer on death accounts, beneficiary designation forms. And I'll talk about what those are when we get to it. That may trip up your planning if you don't coordinate it all. Executor, guardian, trustee choices. You shouldn't just choose your oldest child because they're your oldest child. We'll explain that when we get to there, but that's a common point that many people make a mistake on. Asset titles, beneficiary designations, and trusts. How do we do it? How do we coordinate it? Insurance, financial plan, AI, and online planning. Insurance, life insurance may not seem like it has anything to do with estate planning, but a proper plan doesn't just consider what happens when you pass. How do we protect you during your life? What kind of insurance do you have for that? Asset protection is included in there. And asset protection isn't just for people with millions of dollars. Like Mario was saying, if you have any sort of wealth, what you've done, you've spent a lot of work and you've worked very hard to build it. You don't want to have that loss because somebody slips and falls in your home or something happens. Protecting your assets at a lower asset amount is actually more important because you have less to be able to absorb an impact of a claim. Consumer action checklist, that's just a great little point that we're going to have at the end of items that wraps up for you to consider. And that goes towards the organizer that Latanya was talking about.
That comes from my whole life I've lived. If you don't write it down, it don't happen. I like to write it down. And I may shock these three young colleagues of mine, but I actually use something. I will show you because you may not know what this is. A pen. I actually write it on paper, not electronically.
I know what those are too.
Yeah.
So, Sonia, you're up to bat. We're going to talk about starting with a plan and why people need a plan, what factors they need to think about. It's not just getting a standard form. You actually have to consider things. Why don't you talk about the points on slide 5?
Okay, so
And you can't
We-
take 3 hours to talk about
Yeah.
family dynamics.
let's start exactly with that. So we all have different families. And you could tell my bachelor's is in psychology, and I use it every day with clients. We all have different families. It is the way it is. However, because of that, wills and estate plans need to be planned, customized for whatever that need is. So, in a nutshell, there's blended families, there's domestic partners, people that were married in the church but not legally. They tell me, oh, that's my wife. But then I look and it's not legal. So that's a domestic relationship. That's a whole different situation. And a lot of people think that it's the same because this is something really common, especially in South Florida. they've been together forever. They've come from another country because in South Florida, there's a lot of immigrants. So they come from another country. They were together over there for decades. So they refer to each other as spouses, but in reality, they're not. And in the legal world, if you're not married, it's a very different situation. So blended families, domestic relationships. Do you have children with special needs? I have a child that has special needs. So I have a big heart for that. And that takes a very different type of planning. And then when you have that situation, do you have somebody in your family that you are able to rely on or not? So that's another thing to think about. Or are you willing to take on a professional fiduciary to take care of your child? Assets. How are you going to title your assets? Do you have a business? What type of business is it? I work with a lot of physicians and a lot of blue collar construction companies. Very different situation. Construction company, that can be given to a beneficiary. Physician clinic, that requires licensing and specifics that construction does not. So all of those things, you can't just create a will for that. You have to have a real estate plan. And then we can talk about the trust for the protection. I'm sure we'll talk about that in the presentation. But those are just different things. And addiction and mental health and impulsivity. And I could go on. Now that I'm talking about physicians and construction, that's high liability. Lawyers, doctors, if you've got a kid in college that wants to be a licensed professional, that's high risk. So that is something that you need to think about for protecting that child. Another thing, divorces. The rate of divorce is insane and it continues to increase. Okay, you can protect against that. You don't have to, but you can protect against that. And you can also protect against that child blowing it on a domestic relationship also, because they might say, no, mommy, I'm not going to marry her. Okay. But there's a way that you can protect that child from that potentially bad decision that you see. Because sometimes as parents, wisdom comes with age. We see that train wreck coming. They don't. And you don't want to say too much because you have to keep the peace. But with an estate plan, you can actually protect without ruining the relationship that you've got at that moment. And of course, addiction, there's clauses that we can use, gambling, self-destructive behavior, impulsivity, etc.
The statistics on the prevalence of addiction and mental health issues is terrifying. I think it's 1 in 5 people will face a mental health issue during their lifetime. And just making a simple will to leave things outright could be harmful to the person you love most. So let's go back to Latanya.
Sure.
What does a will do?
I'll
So
start
you
talking
can
about what a
see-
will actually does. So think of it as the instruction list for what's going to happen when you pass away. Probate assets, and we'll talk about that in more detail because there's a difference between probate assets that pass under your will and non-probate assets that do not. So a will is not the full picture of your financial life, and it doesn't control everything. And in fact, for certain people, let's say if most of your assets are in a retirement account, like a 401k, an IRA, it may actually control a very small portion of your financial life when you pass. So it's an important document, but it's not the only document. Something to keep in mind here. And that's why avoiding probate does not negate the need for a will and a plan, because you're still going to have some assets that go under it. And even if somebody tries to avoid probate completely, what I found, and I'm sure Sonia and Latanya can talk about this as well and just see what their thoughts are, things fall through the cracks. People are going to miss certain assets that need to go through the probate system. And it's nothing more frustrating than to have a single car that they forgot to retitle into somebody else's name be the sole reason why you need to probate a will. So don't think, and state by state, this can be different because certain states do have more onus on their probate systems that create more difficulty. So maybe you try harder in certain states. Like, for example, I know California, Latanya, it's much tougher probate out there than it is by us in New Jersey. So you need to make a conscious decision on what you need to do, but avoiding probate should not be the be all and end all of what you're doing in your plan. crafting something that makes sense for you and your family is important there. Now, what does the will do after all of that spiel? It will name a personal representative, also called an executor, that is the person that does and executes, that's where executor comes from, the instructions that you've put for them in the will. Now, I had talked about in the past a little bit ago, who should you name as the executor or the personal representative? Don't just name your first child because they're the first child and they're the natural choice. Consider, what steps are they going to take? Who is better with finances? Who is better dealing with talking to banks or multiple institutions? Who has the time to do something like this? If you have a child that has their own children, your grandchildren, they may be too busy in their own life to deal with something like this. You might want to engage with and talk with the people that you're naming in all of these positions to determine, hey, is this something you actually want to take on? Is this something you would feel comfortable doing? And how would you be okay with doing it? So even if somebody has the ability to do something, if they have the time to do it or not, should be a consideration as well. If you're younger, nominating guardians for your minor children, who are going to take care of your kids if you're gone. You don't want to leave that blank and leave it to the court system to decide who is going to raise your children if you can't do so. For young people, this is one of, if not the most important reason to have a will, because you don't want the court systems to decide who it is that takes care of your kids after you're gone. Your will may create trusts either for your children. We've talked about a couple of reasons why, and we'll talk about some more later. And also deal with charitable gifts. If you're charitably inclined, do you tithe? Are you religious? Is there other things that you want to leave a legacy for other than your children? Your will is going to deal with that, whether it's the amount that you're leaving to them, whether it's if something happens to your children and how would you want your assets to go in that situation. Maybe you leave it to charity then. You want to build all of the what ifs of what may happen in your life into this document. It's an unfortunate aspect to being an estate planner. We're like the Chicken Littles of the world because we always think of all the things that could happen when the sky is falling because we've seen the sky fall for other clients. So I hope that you never have these problems come up, but it's better to have it in place and not need it than to need it and not have it. Consider that for all the points that we're talking about here. Tax and expense allocation. If you have tax considerations, whether it's state, if you have a state estate tax that's lower than the federal estate tax, maybe you have some considerations there. Some states have inheritance taxes that may come into effect at very low amounts of money. For example, New Jersey has inheritance tax if it's going to anybody other than immediate family, like your children or grandchildren. And if there is even an exemption, because some of them don't have it, it could be as low as 50,000, 25,000. So you need to look at, just because you don't have enough money to reach a federal estate tax does not mean that there aren't going to be taxes that need to be dealt with as part of your planning. So that may be lower on the priority because you want to take care of your family first, but it's something that is part of a comprehensive plan you should really be looking at here.
And so key decisions that you're going to have to make and consider when you're creating your will is who is going to be in charge for you, right? So Tom talked about what an executor does, or personal administrator, depending on where you are located. But it's important to think about who that person is. And oftentimes the go-to for families are who's the oldest child, right? And that's not necessarily the best way to go. And so I always spend time talking about who could do this role. Who do you trust? Who do you know? Who could you call at 2 a.m. and you know they would take care of things, right? So really take some time, not just who's convenient, but thinking about who could really do this for you and do it well. Who will know the right questions to ask, who to get help from if necessary. And then we get into talking about the assets, who gets what, when, and how. In my practice, I mentioned I use a form. My intake form gives me information about their assets, but I also ask questions about what's important to clients, what their goals are. I try to get into some of their family dynamics and the things that are important to them, their values. So I know all that by the first time we meet. And so it makes it easier now when we start talking about who gets what, when, and how. Sometimes it's uncomfortable if we talk about, Sonia mentioned having a child with special needs. When you throw that into the equation now, things may not be equal. when you're talking about distribution. And sometimes parents aren't comfortable having a conversation about what could be perceived as treating their children differently. And so if you don't know who they are and what's important to them, it's harder to navigate that conversation. And so I think getting to know your clients helps them and helps you counsel them through the process of talking about who gets what, when, and how. And then also, we talked about how things often change. We can't just think about now. We also have to look into the future. We have to think about what else could possibly happen if the laws change, as they're prone to do, if a beneficiary dies before you do, right? If your estate grows or if it shrinks. And so having those conversations, that's up to us as the professionals to really guide our conversations and our clients to think about all of these things in totality. Having the conversation about if it should be given outright or if trust should be set up through the will instrument. I often find, again, that goes back to what are your goals? What are the family dynamics? If you know who your children are, it's easy when they're adults because you've gotten to see how they would turn out. It's a little bit harder when you're doing this when they're young because we don't know how they will be. And so sometimes that determines if you're going to give outright distributions. We have two children. They're both young adults, a 19 and a 24-year-old. And I wouldn't want either of them to have a large amount of money anytime soon, right? They are great kids, but they're also in school. They're learning. We know everything is set up to be given to them in trust, but that's not always appropriate for every family. I deal with a lot of clients who have adult children and they're fine with outright distribution because they don't want the hassle of an extra administration. And so I always see it's not my goal to tell them what to do. It's to inform them about their options and talk to them and counsel them through the decision and then help them hopefully feel empowered to make a decision that works for them. I think I talked a little bit already about that equal and equitable or different treatment, but I do find that's a place where sometimes you have to take a little bit of time. And as an objective third party, I can help walk families and clients through this conversation and help them feel okay if they make a decision that's not necessarily equal. But beyond that, I also talk to them about how they can have that conversation with their children if they decide to, so that it's not a surprise at the end. It's important to discuss who will bear taxes and expenses. A lot of my clients come to me not knowing a lot about this, and they may not have someone, a tax professional, who helps them. And so sometimes my job is to talk about this with them and then point them to people who can give them a deeper level of knowledge if necessary to help them make that decision. And then, of course, what happens if someone dies first? How do we set it up so that if they're not there to take, who does it go to? And so, again, I find all of this is much easier when you know who your clients are. And unfortunately, that's what you don't get with forms. You're just filling in and there's no one there to probe or pick up on issues that might arise in conversation. You're probably not going to really get a plan that's really suited and customized to your needs. So you may get something, it just may not be the best thing for you and your family.
Let me make one comment before we go on. Infused, and I couldn't count fast enough throughout all of Latanya's comments, one word kept coming up that is critical to getting a good estate planning result, not just a form. And the word that kept coming up is conversation. We as lawyers have conversations with our clients. We are objective because we're independent. We're not part of your family. We can think objectively. If you're going to prepare, if because of financial constraints, practically speaking, this is going to affect most people, you're not going to hire an attorney to do the documentation. Using an online service, and I don't think AI is there yet. I think using an online service is safer. The key thing you're missing is not just the legal knowledge, the conversation, the objectivity. What I've suggested to people when practically they have to use an online service because they can't afford to go to an attorney, don't do it alone. Get 2 or 3 friends. I think more becomes a party and you're not going to focus, but 2 or 3 friends, maybe even 1 friend, who understand and know you and you can talk to, but are objective. None of us can be objective about ourselves. It's kind of hard to do. Lots of soul searching and introspection. That's why a therapist can see things like that we've spent decades struggling with. Objectivity. When you go through the process of filling out the intake or questionnaire that Latanya mentioned, when you go through the process, if you're going to use an online service, or if you're really fee conscious and you've hired a lawyer, have conversations with people that know you first. Your best friend, Jane, may say, hey, Tom, what are you kidding me? You can't name Marty as the executor. He's stingy. He's never going to take care of your family right. You need someone who's going to question what you say so that through that, and I'm going to use Latanya's word, conversation, you realize things that won't work. That is a key if you're doing this without an estate planning specialist. So we've talked a little bit about executors already, Sonia, but see what you can add that hasn't been mentioned already.
We've covered a lot. What I can add is if you have a special needs child, or if you have minor children with mental health, physical health needs, etc., you should also think about having someone outside of the family that is a professional fiduciary to take care of the finances, and someone that you trust to take care of the child. You can have both, and it can be two different people or two different entities. People don't know that. You can have a person that takes care of the child physically, but then you can have a separate person designated to take care of the assets. And you can also leave a letter of care, which I always advise my clients. And we actually did a webinar about that, Marty, where we talked about that. A letter of care that the parent leaves to that individual that is going to be primarily taking care of that child. And in that letter of care, you can go into detail on everything that child needs for a stable environment, stable health, stable eating, etc., depending on what that child needs. That's something that people don't think about, but if they have a special needs child, that's something really important to keep and to really consider that option of having a separate person that takes care of the child as a minor and then another person that takes care of the money. Some of us are just not blessed with someone that can handle both. So that's an option out there for people to know that is available to them.
Okay. Latanya, talk a little bit about guardians. We've talked a bit about it, but some of the questions are, what if I want to name my sister and her husband? Can I name two people? What are some of the characteristics? What are
Yeah,
some of
for
the
sure.
considerations?
Yeah, I think Sonia was just touching on this too. I always spend a little bit more time here with my clients who have children, minor children. And I ask them to think deeply about who do you think would do this like you? Not exactly like you, but who might carry on some of the traditions and help instill the values that are important to you. Sometimes we list them out first. What's the most important to you when thinking about who might raise your children if you cannot? And sometimes people haven't taken time to even think about that. And so I know I mentioned conversation a lot, but it's just something that's important to me, that whatever plan I'm building is really targeted and customized to that family. And I don't know another way to do it without talking to them. And so asking some of these questions they may not have thought about. And then, as we've touched on before, helping them understand that person doesn't also have to be good with money, because you can have different people in those roles. And so I think that kind of helps allay the fear sometimes. And so we know that family can be easy, right? A sister, a brother. But what if you don't like your sister's spouse? Is that the best environment, right? Maybe you have two friends who would be excellent. You've known them for years and you know that they would raise the children similarly. Or if you leave a letter of care, they would follow it to a T. And so I think really just when you present the options, I think it helps people feel more comfortable about making a choice, even if it's not what we might consider a traditional choice, maybe grandparents or siblings. And so opening up, I think, the spectrum of who can do that is helpful. And I often talk about balancing the money and the care. And so sometimes people don't want to go that route. Again, it's not my choice to make. It's just my job to share the options and then let them make the decision, and just talking about what that might look like during administration, because we're planning, but I also want them to have an idea of what this would look like in real life, because someone has to actually carry out the plan. And then I talk to them about, once we do this, also talking to those people. Like, you don't want it to be a surprise. And so having those conversations with the people that you want to take care of your children and the money. And so I, outside of the plan, the money is one thing, but what's more important than our children? So I think this
Nothing.
is really
Yeah.
a really good time to help clarify the roles and how we can set this up so that their kids will have the best possible situation and outcome.
One quick comment on guardians for minor children and trustees for minor children. Look at life insurance. You may not have significant income or wealth,
Yeah.
but if God forbid something happens to you, there's going to be needs for money to help take care of minor children, at least till they get to adult age, or hopefully even through college. Or insurance when you're young and healthy is very inexpensive. And I've seen too many young couples just not buy insurance, and I'm not sure why. So definitely look into that. And this is one of our key take-home points of the whole program. If you go online, you get a document, and you don't buy life insurance and you have young kids, and God forbid there's something bad that happens, those kids are going to struggle for probably their whole lives. A simple purchase of insurance can complete that plan and really protect your children. And again, at young ages, if you're in reasonable health, it's very inexpensive.
Cheaper. And Marty, to that point, before you move on, if you have an intake before they come to you, you're already going to know if they don't have that. And so when we get to this part where we're talking about guardians, that's a great time to share that with them. This is something else to consider. And then hopefully have someone you can refer them to.
And if you're doing this stuff on your own online, this is why you need to take a holistic, comprehensive approach. Because believe me, I'm not aware of any online service, and I've actually prepared forms online to see how they work. They don't prompt you, hey, do you have life insurance? They don't care. They're selling you a will form or a Rev Trust form for a couple $100. They want to make their money and make it not too hard for you so that you'll pay and move on and tell your friends to use it. This kind of stuff is fundamental to protecting the people you love most. Sonia, give a rundown and an explanation for lay people what the other stuff is in terms of documents and what the other stuff is in terms of beyond documents.
Basically, in an estate plan, you've got your pour-over will, which is an umbrella that we use in Florida for whatever has not gotten deeded into the revocable trust. In this slide, we can go in order, and these are the things that are essential in an estate plan. Aside from the will, which we already discussed is used primarily when you have minor children and you want to nominate a guardian for those children, you want to have a durable power of attorney. In the state of Florida, there's a lot of elderly, and in every guardianship case that I have handled, one of the first and main questions that the judge will ask is there a durable power of attorney? If there is a durable power of attorney, there is no need for a guardianship. That person does not have to become a ward of the state. That person does not have to lose all of their rights. A durable power of attorney makes the children's life, or whoever that person of trust, that person of confidence's life, a lot easier. And that individual that needs the help, their life a lot easier, because you are granting the power to help you. Aside from that, all of the healthcare proxies and the medical powers of attorney, the healthcare directives, that includes HIPAA and healthcare surrogacy designation and a living will. All of those are basically powers of attorney for medical purposes. I don't like to use legalese, especially in this context, because this is for the people. So basically, you want a durable power of attorney because that is going to protect all of your financial life, whether you have a house and you want to rent that out, whether you want to evict people from that house, whether you want to have that individual be able to go to the bank for you, pay bills for you, etc. All of your logistics. And then the medical powers of attorney are what's going to help you to have somebody that has your back in the hospital. If you have a car accident, if you have a surgery, if you have any moment where you cannot make a decision for yourself. Having these powers does not mean that you lose powers. That's really important to highlight here. People sometimes worry that if they create a power, especially a healthcare directive, they're going to lose their voice. No. The reason for these healthcare directives is to give you a stronger voice, to strengthen it by giving you a backup. So that's important to know. And then the revocable trust is basically one of the tools that's used to be able to empower you to designate how you're going to distribute your wealth, how you're going to protect your children, like I mentioned earlier, from any type of divorce, from any type of lawsuit, whether it's a car accident or a professional lawsuit, whether they're impulsive or have addiction or have mental health or have disabilities, etc. All of those things are designed for in a revocable trust. And of course, the revocable trust has the step-up basis protection as well, which helps the beneficiary to be able to save a lot of money with the real estate. All of the real estate that you put into a revocable trust is going to allow the beneficiaries to sell it at a step-up basis. So let's say, for example, Florida, I know California, real estate is just crazy everywhere right now. Florida, it's still booming. I don't understand, but still up there. So let's say you bought a condo for $100,000. And at the time that you pass away, the condo is worth $1 million. So now your kids, if you put it in the revocable trust, your kids or your beneficiaries will be able to sell it at 1.1, let's say, and they'll only have to pay the tax on that 100,000 increase in that property, not from 100,000 to 1,100,000. So it's a really big benefit that people are not aware of. And that's one of the attractive parts of having a trust. The other part is insurance. Of course, you need insurance. Aside from protecting your children, you're going to protect your home. Because let's say, and that's for adult children too. Let's say that your house, your condo that you bought for 100 grand is now worth $1 million, and you took a loan out on it, on the equity. And so now there's a debt on it. If you did not have life insurance, that debt is now inherited, and those kids can now lose that property. So you want life insurance to be able to protect that real estate that you worked so hard to obtain for your family. And in that way, you're going to be creating generational wealth and helping them to step up in the world and then create that for their own children. So that's why a will alone is not enough.
I think that's a critical take-home point of our entire presentation. It is National Make-A-Will Month. It's a great title because everyone knows what a will is, and I think everybody kind of knows why every adult should have a will. But you really need National Make-A-Estate Plan Month, but that's a little too complicated. But that is what everybody needs, everybody. Tom, I think you're up.
Sure. So
Not
one
too
point,
long, not too long.
not too long at all, because Sonia covered a lot of this, and I think
Yeah.
that one of the things that we've really helped discuss here is a lot of people, when they think of a will, they think of what's going to happen when they pass away. But estate planning is not just about your death; it's about your life, and that should really help make you feel a little bit better because it's less macabre when you look at it from the I'm protecting not just what's going to happen after you're gone, but I'm protecting you. And a revocable trust is a great vehicle to use to help protect you during your lifetime, not just after you're gone. Think of your finances as like a baton in a relay race. You're dealing with your finances, you got the baton in your hand. Let's say something happens and you need to pass it off to the next person in that relay race. You become incapacitated. God forbid there's a car accident, an acute event, or just as we age, we start to slip. As we cognitively decline, we can't handle our finances like we could have in the past. What happens in that passing of the baton? When you give it to the next person that's going to take over your finances, that is a critical time because if it's not done properly, that's when bad actors, financial abusers, anybody that's going to take advantage, that's an opportunity for them to do so. Having a system to pass off the control of the finances is a way to prevent any sort of financial abuse from being able to affect your planning. And if you have limited means, any sort of financial abuse could significantly impact a percentage of your wealth. Like Mari was saying, if somebody has $20 million and they accidentally wire $500,000 to somebody else, they still have $19.5 million. The heirs are going to be able to deal with that. But how many articles do we see these days of elderly people that wire their entire life savings to somebody because of a romance scam? Or they call them saying they were the IRS and they need to do this. You may say, oh, I would never do that. But we all have moments of weakness. Having the guardrails, having a system helps prevent those situations from happening. The revocable trust can coordinate that. It can create succession in any sort of crisis-driven transfer of control. But what about when there isn't a crisis? The slow slipping as we age. Having people know what's going on in your planning makes a difference there. It really can help here. I think we've covered everything else here, and I want to move us on to talk about more.
Just to summarize, key point that Tom made, revocable trust, yes, they're a powerful tool to avoid probate, and avoiding probate is probably generally, if not almost always, worthwhile. But a revocable trust well done is not just about avoiding probate, it's protecting you as you age, protecting you if you lose cognitive capacity. So it can be much more. Latanya, let's talk about trustee selection and governance.
Yeah, I think I would say similarly to when we talked about choosing an executor, I have the same kind of thinking. Who's going to be the best in this role? And so if you have a revocable living trust, of course, that's you while you're alive. And then when it comes to incapacity and succession, someone else is going to step into that role. And so I won't go into that too much more. I think we talked about that earlier. But again, the idea that it doesn't have to be one person. You can have someone who invests and manages assets. It really just depends, I think, on what is in the estate and what clients are trying to do. And so sometimes clients will have the grand ideas about what they want. And then it's my job to talk about what that will look like in administration, especially in relation to the person they're choosing to do this role. And so again, just guiding them through that process. But one of the things I see there and I want to touch on is in the box, because this idea of naming all the children to be co-trustees, that comes up often. And really just talking clients back down from that and really sharing how that will probably create more difficulties and go against what they are trying to do. And then that usually helps them see that it's okay, again, to pick one person. You can put guardrails, we can build guardrails around anything you have concerns about. But again, as much as possible, if the goal is not just passing on assets, but it's oftentimes ease as well. And you don't want to create consternation and friction because it's so hard to administer the plan. And so for me, whenever we're having a conversation about trustee selection and governance, I always go back again to what your goals are and what the family dynamics are. Because sometimes they all have to match. They all have to work together.
Before we go on, a quick comment. What Latanya talked about of guardrails as an example. If you feel that your situation is simple enough that you can use an online service safely, and you go about that because cost is a concern, trying to be fair and realistic for many people. But as you get into the process and you're having, I'm going to use the same phrase again, conversations, have somebody objective you can talk to, and you realize that there's some special circumstances and you need guardrails. A beneficiary with an addiction issue happens in a large number of cases. That's when you may need to blow the whistle and say, you know something, it's expensive, but I probably need a professional. I think you need to be very careful as a layperson, non-lawyer, even if you're a skilled estate planner in another field. But if you're not a lawyer and you don't have the skill drafting documents, it's one thing if a fairly standard form can work. But if you want to modify it for your unique situation, that's one of those red flags when you start to need to really rethink whether you should be doing this on your own or not. So, Sonia, one of the issues, as we all know, is that assets based on beneficiary designations or how they're owned or title can not even be subject to the will. I remember years ago having a couple come to me and they wanted me to do a will. And when I looked at their balance sheet, they had, I think, $5,000 in a checking account that went up and down. They put their paycheck in, they spend money and move savings someplace else. Every asset passed outside of probate because of title or beneficiary designation, house, insurance, retirement plans. And I actually sent them to somebody who could do the work much less costly than me because there's never going to be significant probate assets. I don't think the average consumer understands what I just said. Maybe explain it more intelligently and more slowly and carefully so that everyone can get it, because this is really important.
This is my special talent, breaking down legalese into plain English or Spanish. In plain English.
Yeah, do it in English today, though.
Yeah, it's me. So, retirement accounts, Roth IRAs, stock, basically. Those, if you have a beneficiary listed already or contingent beneficiaries, you usually do that on the website. If you have that, then that means that you have to update it and keep in mind who you've got listed on there. Because if you have a blended family or you just got divorced and you pass away and you don't update that, you might end up giving all of that money to your ex-spouse. I don't think that was the intention with a lot of people. So you want to make sure that if you are doing that, you constantly keep in mind who you've got listed. So that's for the retirement accounts. For the life insurance and annuities, it works the same way. You have to understand that if you are going to have a will and a trust, and you want that to be the rule, then everything has to go together. So you have to title those things, basically put the name of that trust into those assets, into the retirement account, the Roth IRA, the life insurance, the annuities, so that the beneficiary would be the trust and it would go to the survivors with the instructions that you gave in that trust. So that's basically how it works for those accounts: insurance, life insurance, term life insurance, retirement account, 401k, etc. And then the transfer on death account, if you have that in your bank account, whether it's checking or savings or a business account, a lot of people do that, then keep in mind that that's not going to be a probatable asset. That's not going to go into probate court. That's going to go straight 100% to whoever you listed as the person that is on those papers. And that usually you have to do in person at the bank. And each bank has a different form, but you just tell them, I want a TOD form, and then they give it to you. Then it should be simple. Pay on death and TOD, same thing. You just go to the bank and ask them for a POD or a form. Sometimes they've got it online, but you typically, I would assume every bank has the same requirement because it's federal. You go in person and then they notarize that form so that it's official.
I think the most important take-home point from Sonia's comments, yes, you need a will. Even if you have a revocable trust, then you need a pour-over will. You need a will. But if you don't understand beneficiary designations and how your assets are owned, you have no idea what your will may do. It may do absolutely nothing. Nothing. You can't just get a will without taking care of ownership and title to assets and beneficiary designations. And Sonia made a comment which may have sounded silly, but I'm sure if we polled us, we've seen it more times than not. People forget to update their documents. They have 2 kids and they name the 2 kids as beneficiaries of an IRA. They have a 3rd kid, they forget to update it. People need to think. You need to think about what you have, keep records of what you have. And this is why you need to do housekeeping. You have to take an inventory once in a while and go back and look at all these things. And I'll tell you where I see most estate plans ruined, whether people have lawyers or don't have lawyers, whether they have financial advisors or they're doing it on their own. When they change firms where their accounts are, everything that they knew before about how they have to title assets and title accounts and list accounts, they forget when they go to a new institution and everything gets ruined. Make sure you pay attention. Make sure you understand the plan, whether you're doing it online with a lawyer, with an estate planning specialist. Get the financial ends of it and the asset ownership coordinated with whatever you're trying to accomplish. Sonia, just real quick, because I think we got to get on to other topics. Just quickly mention a few points on slide 16.
Okay, so as I mentioned, if you have a direct beneficiary that you already listed on your Roth IRA or any of those accounts, then the trust is not going to apply. That money is going to go straight to whoever you listed. So you want to make sure not to do that or to be very aware of who you listed. Joint accounts, a lot of people say, oh, I'm just going to have my daughter on my account, no problem. Guess what? Your daughter gets divorced. Now that's a marital asset. So now what you were
Ouch.
trying, yeah. So we haven't even talked about that. So you were trying to protect that money and to give it to her in case you pass away. But guess what? Or when you pass away. But guess what? Now they got divorced, or now they have a creditor on them because they didn't pay their Macy's credit card, or they get sued because they hit somebody from behind. And oh my goodness, now it's they got a big PI lawyer that took the case. And now you're going to court and you're going to have to settle, and they're going to see that account, and that account is not even rightfully hers. It's yours, but you're going to risk losing it because you did a joint account. So you don't want that. You want a transfer on death if that's what you want, but not a joint account.
So, Tom, I assume you're in my camp where you believe everything should be in trust. Explain really simply what a trust is. Explain why people don't want it, and explain why that can be a tragic mistake.
So think of a trust as like a contract. You are hiring somebody to take care of the finances for your children. So there's multiple people involved in a trust. There's the trustee, who we've touched upon. There are beneficiaries who receive the financial largesse of the trust. They're the ones that can have assets distributed out to them. You, as the grantor settler, the fancy name for the person that created the trust. So you are entrusting the trustee to take care of the finances for the beneficiary. Now, there are times where somebody can wear multiple hats in that trust. There are trusts where maybe you set up so that your child is the beneficiary, but you also name them as the trustee. But that child then needs to take the steps to do their different positions. They make distributions to themselves, but they could affect the asset protection, like the divorce or creditor exposure, the lawsuits and professional liability. That being said, having a trust, think of it as like a tub of toothpaste. You've got the assets in it. If you squeeze some of them out, it's very messy to get them back in. In the same way, if you are giving money to your children when you pass, if you give it to them outright, that's it. They've got the money. It's now reachable by their creditors. If they get divorced, half of that is, or a percentage of that is going to their ex-spouse. If instead you set it up as a trust, that's the one opportunity that you get to create this trust for that money without having a lot more troubles. They can create trust themselves, but that is more complicated. There's less clear protection than if you set it up for them. And if you give them a trust and they choose at a later point to squeeze all those assets out, at least you gave them the opportunity and the option to have it in the trust. So think of it as it doesn't hurt to have it. And if they choose to bust the trust, that's their choice. But if you give it to them outright, the opportunity is lost, period. I've got a whole bunch of reasons here why you should put something in a trust. I'm not going to go into much detail because we've already touched on a lot of these. But the whole point is this is a way for you to create a structure and a vehicle to protect the next generations, not just your children, but your grandchildren. You pass down your values. You keep the money in the family and prevent dissipation over time, which helps facilitate the growth of family wealth. It is a way for you to create a system that breaks the cycle of continuously dissipating wealth. It really can, if done properly and thoughtfully, help you and your family.
Sonia, this is for you. So, Latanya, I'll get you on the next one. We've covered a lot on special needs and disability planning. Just see if there's anything you feel we should add. We're good? Okay. Latanya, all wills shouldn't be standard.
No,
Maybe just make a couple of comments.
for sure.
This could be a 2-hour talk, so just do it in a minute.
And I'll be very brief. And I think the whole idea just behind this is when you get to know your client, part of that is getting to understand what about their lives might impact how you plan for them. So there may be instances when you're working with people from certain religious communities or cultural communities that they're going to do things differently than you normally would. And I think that goes back to we're not here to impart what we think should be done. It's really seeing what's important to them and then how we can use the tools that we have to help them make a decision that's going to work for them. And so I see this often come up in religion, culture, but I think professionals who are not mindful of this, just this idea that you might need to differentiate can easily offend clients or not serve their needs. And so I would just say be aware, getting to know your client is hugely important, but delving in and asking some of these other questions because those things might impact what goes in that advanced healthcare directive, right? If blood transfusions are not allowed in the religion, don't put that in there. I have clients that feel very strongly about organ donation. And that's because there's a history of experimentation. And so, whereas I might think it's a great thing to do for humanity, they don't. And I wouldn't force them into that. And so, really just taking the time to understand how religious and cultural considerations might shape how you plan for families.
This topic is really important for an
Huge.
awful lot of people. Let me go through the sequence. If you're preparing documents, and I'm going to leave AI out because I don't think asking AI to write a will is there yet. If you have an online service you're using because it's too costly to go to an attorney, if you have really strong, important religious, cultural, heritage type issues, I don't think you're going to get this stuff tailored for you. You can go to a faith-based website to get a religious-oriented, say, health proxy or living will. But a lot of times you have to keep in mind they're trying to make this really easy for anybody of that particular faith to get a document signed in any of the 50 states. So I don't think sanitize is the right word, but simplify the documents to just focus on the religious considerations. Those documents may not give you everything else you want. It's a great starting point to find out what does the faith that you adhere to suggest be in a living will, but make sure the documents work. But many of the faith-based sites really just focus on end-of-life medical decisions because there's so many profound religious implications. So you can't use that to infuse religious, cultural, value-based philosophy, your philosophies on life into the plan. When you do that, you really need to go to a lawyer. And I would even suggest, and in many parts of the country, there are only general practitioners. In rural areas, for example, you may not find an estate planning specialist. But if you really want something finely tailored, if it's important enough to you, you probably want a specialist who can do it well and address it for you. So
Yeah.
I don't want to say go to a lawyer, but you got to know when you may need it and when you might be able to work around it. Sonia, we're running out of time, so we got to be fast, but talk just briefly about the definition of families, because this is, again, an important topic that is too often overlooked. And if somebody signs a simple online form or even a simple lawyer form, it may not address it.
Exactly. This is a perfect segue. Like Marty said, it's boilerplate what you get online, and life is not boilerplate. Every single one of us four has a very different family dynamic. And we have a lot of similarities, but we have a lot of differences in our personal lives. Like you, the audience also has a ton of differences. So if you see that you've got a stepchild, or that you've got a bonus child, or you have a domestic partner, or you have a same-sex marriage, or you've got a business, you've got a special needs kid, you've got a sickly kid, you don't have Medicaid for that kid yet, but you want to have Medicaid, that is definitely a special thing. If your kid has special needs and is not on Medicaid, you may not necessarily need a special needs trust, but you certainly do not need a boilerplate will. So those are just things to look out for, to protect against a potential divorce, to protect against liability from a car accident even. A boilerplate will is not going to do that.
We've all seen wills and trusts set up that use what I'll call old style or more narrow definitions of descendants. And a couple may use artificial reproductive technologies, art, to have a child because they can't conceive a child. And that child is tragically excluded from the definition of descendants, not because somebody intended it, but because they didn't realize the importance of looking at what they thought was boilerplate. So you have to be very mindful. And if you're going to use an online form or an inexpensive flat fee form from an attorney, that's fine. That's your decision. And a lot of times that may make sense. But if this could possibly affect you, please read these definitions. They're not standard.
So one point I want to bring up on this topic before we move on, Marty, and that's that every state has different definitions for descendants. If your document does not provide a definition itself, it's going to go based upon state law. And when you consider things like IVF, assisted reproductive technology, the law, unfortunately, in many ways is not keeping up with the speed of evolution that we're having. I'm just going to give a quick client example because I think it shows this situation. We had a same-sex couple, 2 wives, they had 2 kids. Child number 1 was conceived with the egg of wife 1, and wife 2 took the child to term. Under New Jersey law, that child was the child of both of the wives because it was wife 1's biological child, and wife 2 conceived the child naturally. Second child was both wife 2's egg, and wife 2 carried it to term. Under New Jersey law, that child was not the child of wife 1. Wife 1 had to do a confirmatory adoption to make sure that child was considered their descendant. And we're talking about estate planning here, but that has repercussions beyond estate planning as well. What about guardianship? If wife 2 was to pass away, does wife 1 automatically have a claim to take their own child after wife 2 passes away? What about healthcare decisions? What about dealing with education, students? They're not considered a true parent under the eyes of the law in that situation. So making sure that you have all your T's crossed, your I's dotted in this situation could really make a difference, not just for your will, too.
And don't assume because state law does what you want, that's enough. People move. What if you move to another jurisdiction and it doesn't agree with that? LaTanya, just briefly talk a little bit about why people need to do financial planning.
Yeah. Well,
Because they assume that's separate than estate planning, but will they have money left to leave?
exactly. They're interdependent, really. And
Great
so
word.
sometimes I have clients that come already. Those are my easy ones usually. They already have a financial planner and they've got things in order. And so it's just a matter of collaborating and coordinating with them. It makes it much easier. But probably more often I have clients that don't have a financial planner. And so as we're planning, it's a perfect time to talk about, as we're talking about your goals and what you're planning to protect and prepare to pass on at some other point, we want to make sure the estate is there at that time. And so it's a perfect opportunity while we're estate planning, if clients don't have a financial planner, that we can help them get one and then get started with that work too. I often talk too in this space about if you have children right now and you don't think they're ready to handle your estate, having a financial planner is a great way to introduce them to the process, get them involved in it as well, and build up their knowledge and skills so that when they do receive their inheritance, they're able to manage it and handle it. So I definitely think it's essential to have that financial plan. Like I said, they're interdependent. And so when clients don't already have one, try to connect them with someone who can help them in that respect too.
Let me amplify what LaTanya said. One of the greatest gifts, not just parents, but any benefactor can give a child or whoever they're leaving wealth to, is a financial plan. Help get them educated by a professional about what the wealth means before they get it. You want to maximize the utility, the good that comes out of somebody inheriting money. Help them get educated, help them get a financial plan, help them learn what wealth means. Too often, and we've all seen it, I'm not going to ask everybody, somebody inherits money and the next thing you know, they're driving that proverbial red sports car and going on the cruise, and they've gone through half the money and it's not even 6 months out. Nobody wants that. If you want to maximize generational wealth and happiness, help educate the next generation. I think we've covered insurance. The only point on this slide is there's lots of different types of insurance. Different people need different things. You can't safeguard your estate if you don't have proper liability and casualty insurance. You can't safeguard your estate without proper homeowners and auto insurance. If you're working, you need disability insurance. You need to look at it. Again, make a will month. Every adult should have a will, but you need more. And again, it would be wonderful if they could have had it make an estate plan month, but I just don't think it has the marketing appeal of make a will month. AI and stuff we've talked about. Again, I want to repeat this because it's so important. You have to make sure that you do what makes sense for you financially. Doing nothing does not make sense. If you have to spend little money because you can't afford it and you go online and do it, I want to repeat some of the points I made. Fill out the organizer like Latanya talked about. Get a friend to have a conversation with so somebody objective can say, hey, Tom, that makes no sense. You know it makes no sense. You're not doing that. You need that kind of help and prepare yourself. Use these materials and read them and study them and learn them and understand them if you're going to go online before you go online so you understand what the planning is about. If you can afford and get a lawyer, that's great. If your stuff is not really specialized, a general practice attorney that's done a meaningful amount of wills and estate planning, that's a great option. If you have really nuanced specialized stuff, and that's a bit of a judgment call, you probably want a specialist. So it's a little bit going up the chain of cost and complexity and expertise. And it's like the three bears in the porridge. You want to do not too hot, not too cold. You want it just right. And listen, what's right for you today may be different than what's right in 10 years from now. Tom, real quick, talk about signing, safekeeping, and updating. And we got to wrap up soon.
Sure. So I'm not going to take on to this very much, but similar to what we were saying about the rules for modern families and definition of descendants, every state has different requirements for signing a document. And like Marty said, we often move. If you move and you have a will from your previous state, first of all, you should update it for your current state's law because that's going to be different. But if you don't have the opportunity to do, what if your current state's signing requirements are different from the previous state and you did not sign it well enough to properly be considered a will in your new state? So we always say belt and suspenders, do more than you need to at a minimum in order for something to be considered a will. If you have two witnesses and notary, that's a good standard that will get you in as considered being a will in almost all states. So that's a way for you to, I guess you could say, move proof your will in a way. You also need to have it kept in a safe spot that's both accessible and where people can know that it is. Because if you've lost the original will, it may be presumed by the court that you intended to revoke that will. You destroyed it, and that's why it can't be found. Another point, and it's saying it right here, safety deposit boxes. They become a catch-22. If you're the only name on your safety deposit box and you pass away and the bank learns of that, they're going to lock down that box until they have proof that the executor has authority to access the box. To get that authority, the executor needs the will to probate it with the court. If the original will is in the box, you've now got Schrodinger's will. Does it actually exist? Because they cannot get in the box to get the will to prove that they can get into the box. So avoid safety deposit boxes. We've had clients in the past who are rushing to the bank after their loved one just died because they want to get there before the bank finds out the person passed away and locks down the box. You don't want to put anybody in situations like that. Electronic copies. If you don't have the original, or if you want to keep the original safe and not take it out every time you want to look at it, if you have a PDF copy of that will, that's what you can use in your daily day-to-day life as you're looking at. And that should be for all of your documents, not just the will, powers of attorney, revocable trusts, if you have them, irrevocable trusts, any of these documents that you have. And finally, you don't have your car and drive it for 100,000 miles without doing an oil change or checking on it, doing all the routine maintenance that you need to have done. You shouldn't assume that because you have a will, you can put it in the back to have the spiders put cobwebs all over it for the next 40 years. Laws change, family situations change, who you want to name, what's important to you changes over time. You should really look at least every 2 to 5 years you're planning. If you have complicated planning or you're naming multiple different people or giving money to many different people, maybe you want to do it on a shorter timeline than if you have a very simple, and I know I'm using a taboo word here, plan where it can last a little bit longer. But make sure that you're thinking of your planning and updating it in an appropriate time frame.
I think we've covered a lot of this. Let's close, and I'll ask Sonia, Latanya, then Tom to make just a closing comment.
In addition to everything that we listed, a very important thing that I'd like to highlight to people is to mention personal property. Aside from the real estate, aside from the Roth IRAs, aside from the bigger assets, mention who will get the jewelry, who will get the family heirlooms, who will get mom's wedding ring, dad's wedding ring, who will get artwork if you have any religious artifacts that mean a lot to the family. Sometimes, or oftentimes, I have to say, things that are not valuable financially have an incredible value emotionally and end up in court and end up taking thousands and thousands of dollars from people, even people that don't have those millions of dollars to waste in probate court. So that's one thing I'd like to add that we didn't touch upon, and that you can do with an estate planning attorney or without, but keep that in mind.
Latanya?
Yeah. I would say a will is a great place to start, but it's often not enough. And I always urge, have as comprehensive a plan as possible. And if you can afford it, have someone who knows what they're doing, a specialist, help you do it. If lay people often don't know what they don't know. And sometimes you don't know what you don't know. And so while there are other options available, and I do think access is greatly important, but sometimes you won't know if it's wrong at all, and it'll be your family that has to figure out it wasn't done correctly. And so if at all possible, if you can get with someone who knows what they're doing to help you with it, do so. But again, a will is better than nothing and a great place to start.
Tom?
I started the conversation by talking about the fact that this is not easy for anybody to address. These are tough situations. There's going to be family undercurrents that you need to really deal with, and you may want to just keep those skeletons in the closet. But think of the myriad of points that we've talked about today and how it's tough to talk about now while you're alive, while you're healthy, while everything is relatively calm. Think about how much harder it would be to talk about that after an event where a loved one passes away. If you're gone and you're leaving your spouse or your children to pick up the pieces, how much harder is it going to be for them if you've not put the planning in place to make that transition that much easier? Think to yourself of all the things that you do in your life. Create a list. The financial things I do, the personal things I do, feeding the dog, taking care of paying the bills, all the things that you do. If you were to be gone tomorrow, would those still get done? Would they know how to do them? Your spouse, your children. You need to think of it for everybody. And everybody should have this actionable list of things that I'm doing, not just so that you understand what you need to address, but it's great to leave with the materials because that will help people know what's going on in your life. That could be included in the letter of instruction that we've talked about throughout this. So really, do this while you're healthy. Do it while you can do it in a calm and thoughtful manner, because if you don't, it's going to be dealt with later and in a much tougher, much more costly way than it would be if you did it now.
So to wrap up, if you don't commit to do something, this was all for naught. Everybody watching this should commit to do whatever makes sense for them, their life, their circumstances, whether it means going online and getting a form, preparing by doing things before you go online, hiring an attorney, hiring a specialist. Commit to do something. If you're not sure where to start, you find the process daunting or unpleasant, we are going to provide you tremendous resources. This video of this webinar is recorded and going to be posted to a whole bunch of different websites. The 3 websites are listed there. Also, I didn't list, but I will add schenkmaneducation.com. But Latanya will post it, Sonia will post it, and Tom's going to put it on schenkmaneducation.com. We may even put it on schenkmanteats.com. We're also going to give you a detailed paper that goes through everything we've talked about and then some. We're going to give you a guidebook of will provisions. And if you have a revocable trust plan, it'll cover a lot of that. So if you want to understand a provision in your will or not in your will, or what something means that you read about, that may be very helpful. We're going to give you 2 articles. We're going to give you the PowerPoint. So we're going to give you 5 written materials and a recording that will help jumpstart everyone. But if you don't take action and commit to take action, it's all for naught. So commit to do something. And if you feel you're on the lower end of the income and wealth spectrum and you don't need this, I hope we've convinced you do. If you're on the higher end of the spectrum, hopefully we've convinced you need more than just checking a box. You need a plan. Everyone needs a plan. So I wish everybody good luck. I want to thank Tom, Sonia, and Latanya for all their insightful help. And you'll see in the PowerPoint on any of the websites a wealth of materials to help you address this really important step for you and your loved ones, however you choose to define that.